Few days ago, we talked about one of the U.S. Supreme Court decisions from the past week that had to do with Civil Rights Act and whether LGBTQ individuals fell under the protections of that act. There was another case that drew some attention, especially given the current temperament with regard to police and misconduct. Talk about that, please.
Well, the Supreme Court decided not to take up issue about qualified immunity. Now, police officers have what's called sovereign immunity. If they're acting within the scope of their duties, they're doing what police officers do, they cannot be sued. Now, qualified immunity kind of makes that a step further. Let's say they do exit the scope of their employment and use excessive force. So what the qualified immunity doctrine does is it asks two questions. One, was it really excessive force? And two, if so, was it objectively reasonable? So it basically makes it okay for police officers to use excessive force and not be sued.
Because of the fact that they were acting in the scope of their duties, and what they did may have departed from the rules, but it was not such an egregious example as to have mendacity, et cetera, that then could lead to some sort of a civil penalty. So the court said, we're not going to look at this. Obviously, the case was filed and brought to them well before all of the events of this year. But what signal does that send in the current climate for police departments and police officers?
You know, Jeff, qualified immunity is nowhere to be found in any statute. This is something that the Supreme Court made up in the 1960s and have been slowly evolving it. Originally, it was there excessive force? And in the officer's mind, how did he feel? Did he feel it was reasonable? If so, that's okay. So that's how it started. It got a little bit better. And now the Supreme Court is like, I know we created this quagmire, but we're still not going to take it up. Maybe Congress, who's looking at reform, might take it up and define what excessive force is and make it illegal.
I laughed a bit because, well, we created this, but we're not going to clean it up, which I guess you can do if you're them. There's the general principle in labor law of respondeat superior, where if I commit some sort of a wrongdoing within the scope of my employment, it's possible for my employer to be responsible if they had reason to know that I might engage in that activity. In other words, the employer is responsible for the employee. But what we're talking about here with the government employee, that takes it up yet another notch, doesn't it?
That's right, because you can sue the police department, the whole city, etc., if they do use excessive force and it was not objectionably reasonable.
Yeah, if they strayed so far from the bounds of what's expected, that's where you cross into a different category. But it's a much wider berth, if you will, for the officer and the government employee as opposed to someone in the private sector.
That's right.